People have been waiting. We have lots of people signing up. Those are good signs. A lot of things are changing and proposals are happening. As international students, we all care about the next steps. So that's why we feel very important at the moment to invite some of the immigration experts, some attorneys to join us. David Gluckman here, join us from Virginia, has been a long-term partner with us. Today, he's going to present more detailed information about the F1 DHS proposal, as well as in terms of commenting what actually power does the students have, what can the student do. So just a little breakdown of today's topic. Everybody might have heard already about the big H1B, the big F1 proposal. So we're going to talk about what exactly are in those proposed rules, and then what will be the next steps during the rulemaking process if they did get it past, the public commenting periods, and then what will be the general timeline and when will some of the changes be happening. Some of the other things we're going to talk about specific impacts. If you are F1 students, if you are OPT students currently working, and if you are using CPT or wanting to transition to CPT, what might impact you if this rule comes true? And then finally, we're also going to talk about the 30-day deadline for commenting period, which we already have passed almost half of the 30 days. The official deadline for the public comments are September 29th. Correct me if I'm wrong. And
That's right.
then the reason why comment matters, and is there any ways that F1 students can be commenting, or if there's anything that you would rather not comment to approach this. So we're going to talk all about that, and we welcome all of the questions from all of you. Again, this webinar serves for the bigger F1 student community, so any questions are welcome. Please send them into the Q&A session that you can see down below into the Zoom chat, and our moderator Shama here is going to collect everybody's questions. Hopefully, we can have David here answer as much questions as we can. You might wonder who we are gathering this kind of webinars. Just a little bit of preview of descriptions of who we are as the host. So we are located in Los Angeles. We're an education consultancy. We mainly focus on helping students do the professional hybrid or CPT programs. We are authorized by AIRC as one of the biggest educational space in education industry. And then we host this type of webinars every week. So whether it's H1B, whether it's F1, if you're interested, definitely go to goelite.com/events so you can learn more about these kind of free events and activities. And then we're on Google Reviews and also on all of the social media channels. So feel free to check us out on all of these channels. And without further ado, I will let David, today's speaker, introduce himself, and then we can go ahead and get started with today's webinar session.
All right. Thank you so much, Ryan. I'm going to go ahead and share my screen here, and then we'll get started with the presentation and all this fun, great news that I'm sure everybody's excited to hear. Just kidding. So anyway, my name is David Gluckman. For those of you who haven't met me previously or haven't been on any webinars that I've done before, I'm an immigration attorney and a director of the Immigration Practice Group in McCandless Holton, which is a law firm in Virginia. We represent lots of universities, lots of university students, lots of employers. So we're really plugged into the stuff that's going on right now. And I sort of want to go over some general information about the process for making a rule like this, the timelines in general, what you can do as a student, and what would be and would not be helpful. Okay, so I'm going to go through those in turn. And like Ryan said, if you guys have questions at the end, I'll be happy to answer them. So, first, like I said, a little background on rulemaking. So, a lot of people think about rules and
A lot
laws
of
as
people think
being passed by Congress, that you have to pass the House and then the Senate, and then you go to the president and he signs it. Well, that's not the case with these types of laws. These are administrative agency rules. So administrative agencies are part of the executive branch of government. So the legislative process is not involved at all. It's all purely through executive rulemaking process that is set up by a statute called the Administrative Procedure Act. So student status as many other immigration statuses, are set by what's called regulations. So if anyone's ever heard of like the 8 CFR, CFR stands for Code of Federal Regulations. And the 8 CFR governs lots and lots and lots of provisions of immigration law. And it's particularly relevant here because in order to make changes to the 8 CFR, they have to go through a formal process that is called rulemaking. So this is different from that House, Senate, President approval. It's a different process, and we'll go through that. Okay, so the first thing is that a government agency like the Department of Homeland Security, they discuss something internally that they want to do, and they draft a rule, and they have to receive internal clearance to publish that proposal to the public. Okay, so that's what they did up until August with this particular duration of status rule. Once they have that authorization to publish the proposal to the public, then the public sees the proposal, and then you have from 30 to 60 days to submit comments on that proposal. Okay, and it's any member of the public, any institution, it can be somebody from outside the US. So basically, there's no requirement on who needs to be able to comment. Okay, anybody can do it. It can even be done anonymously, as I'll talk about in a few minutes. And then once that public comment period closes, the agency is under an obligation to analyze all the feedback that was received, and then they need to either respond to certain categories of feedback and or make changes as needed. So if, for example, there's a large outcry because there's a mistake in the proposal that makes no sense, then that's their opportunity to change that and fix that mistake. Or if there's an alternative to the rule that is identified by a lot of comments, then they will identify what the people are proposing and then either say, yes, this is a good alternative. We're going to be implementing it by changing our proposal to implement this final proposal, or they'll say why they don't think it's a good idea and why their original proposal is better. Okay, so there's really no general timeline on that, but common sense dictates that the more comments they receive, the longer it's going to take them to sort through. And that will lead us into some further discussion later. And then once they're done with that, then they will publish that final rule, and it's going to take effect 30 or 60 days later. In this case, it's going to be a 60-day period between when this final duration of status rule is published and when it actually is going to take effect. So that's good because it at least gives you guys an opportunity to make any necessary life changes or lifestyle choices to accommodate this rule. Okay. So as you can see, it's going to take many months. So it's not a matter of the government's going to accept comments through September 29th and you're going to see the final rule on October 7th. No, probably not going to be a week or two. It's probably going to be at least a few months. So we're going to have some time to breathe, some time to think about this, and some time to react. So that being said, what exactly is being proposed? This is what everybody's been talking about, this rule, since it came out at the end of last month. The main point of this rule is that they're going to replace something called duration of status with fixed periods of admission. So for people who are here on F1 and J1 or an M1, I don't know if anybody has that status, but you'll look on your I-94 record and it says admitted through, and it doesn't have a specific date. It says D/S, meaning duration of status. That means that when you come into the country, your immigration status as an F1 or a J1 is controlled by basically the SEVIS record, okay? And that's maintained by your International Student Advisor, your DSO, and they allow you to extend that, to transfer to different institutions, to change majors, et cetera, et cetera. So right now, it provides a lot of flexibility. You don't really have to interact with USCIS at all when you make these changes. And there's no specific end date saying that you have to leave by a certain date. It's all about whether or not you're making adequate progress towards your degree. Okay. Well, immigration saw this sensible program that's worked for over 20 years, and they said, you know what, let's get rid of this altogether. And they're basing it on a lot of considerations that are flawed. For example, they're saying that people have been overstaying when that data that they're relying on is flawed. They point to some isolated examples of some guy who's been taking dance instruction for the last 30 years. I mean, yeah, these are certainly something that we can agree that that's not a good thing, but they can address that guy and his case instead of having to uproot an entire system that's been working for the last quarter century. So those are things that can be pointed out in the comments. We'll talk about that later. So what they're doing instead of having duration of status is when a student comes in on a student visa, they're going to get an I-94 that is going to be through the end date of what's on their I-20. So if it's a 2-year program, you'll be admitted for 2 years, and that'll be the end date. If you're going to be admitted to start a program that's going to be more than 4 years long, then you can only be admitted for a maximum of 4 years. And if you need to extend past that point, then you're going to need to file for an extension with immigration. So it's going to be a lot more cumbersome. So essentially, what it does is it replaces the school's discretion. So the school would generally make the changes, make those extensions, change, do the transfers. Well, they're going to replace the school with USCIS. So now it's all going to be up to USCIS whether to approve these things. And that's going to be generally done by filing a Form I-539, which is currently filed by all other non-immigrant categories who are seeking an extension of their end date. And then what's problematic, especially, is that let's say that I'm coming here as a bachelor's student and I'm going to study for 4 years, but then I want to stay another year to go forward with my optional practical training. Well, since I'm only going to be admitted for up to 4 years, then I'm now going to have to file both an application for an extension of my F1 status for another year, and at the same time, I'm going to have to file for my work card on the I-765. So it's going to be more fees, more confusion. And for folks who have interacted with USCIS, you know that these aren't the most efficient people out there. They take months and months and months to process even the simplest filings. So it's going to lead to large backlogs, and it's going to be a financial burden to you guys because it's very likely that you're going to end up having to pay for premium processing if they make that available. And then here's a really concerning provision that is relevant to a lot of folks who liaise with Go Elite, is that it only allows for so-called vertical matriculation. So it means you can only go on steps from one degree to another. You can't do lateral degrees. You can't go down. So if you get a master's degree, then they're not going to allow you to do a second master's degree. If you have a bachelor's degree, then they're not going to allow you to go backwards and do an associate's degree. So that's really harmful, and put a pin in that because that might be something that you might want to make a comment on. Another thing is that it prohibits students who are at a graduate level from making any changes to their program. So you can't change to another school. You can't even change your field of study. It's very draconian, hugely restrictive for graduate students. And for undergraduates, it prevents any changes from happening in the first year of your undergraduate education, except for extenuating circumstances, which you can understand under the Trump administration are going to be very rarely found. And another harmful thing is right now, as an F1 student, when you graduate and you complete your studies or you complete your OPT, you have a 60-day grace period to either apply to change to another status, maybe to leave the United States altogether. Now they're going to cut that in half. They want to reduce it from 60 days to 30 days. Very harmful. And a lot of students are probably asking, well, what if I'm already here on duration of status? Is this really going to affect me, or does it only affect me if I travel? And unfortunately, it's kind of a little of both. While you're kind of grandfathered in that you're going to have duration of status, you're not going to be able to stay past your current program end date. So even though it's going to say duration of status on your I-94, the reality is that you really do have a fixed end date, and that's going to be the end date of your current program on your I-20. Okay. You will still get that 60-day grace period. So it's not completely lost. So you do have some benefit from your current duration of status in that you can get that 60-day grace period instead of a 30-day grace period. So really, Trump's warfare against higher education, a less welcoming place for international students. So the question is, can this proposal be stopped, or is it already set in stone? So like Ryan said, the day that you guys want to circle on your calendars is September 29th, because that's when the public comment period closes. And we'll talk about that in a second, but that's what you really need to focus on right now. So like I said on the first slide, all the comments that they receive, they're going to have to review. And they're going to make changes. Now, do they have to answer every single person's comment? No, they're not going to do that. But if a lot of people band together and make the same types of comments, they point out the same flaws in this proposal, then they are going to need to address those various themes. So to the extent you guys can coordinate to identify particular provisions that you collectively want to address, that's better than doing it in a scattershot effort one by one. And then the final rule, like I said, is going to be published. It's going to take effect 60 days later. So we will have some time to understand when this rule is going to take effect. So maybe in that 60-day period, you might want to make some travel plans so that you can come and re-enter before duration of status goes away. That would be a good thing to do. Or if you can file for your OPT within that 60-day period before you have to then file an I-539, that's definitely going to be useful as well. So make sure you pay attention to when that 60-day period ends and that new rule is going to take effect. And then what's nice about the Administrative Procedure Act is it has a very liberal judicial review provision. So while the Immigration Service does not have to address every single comment, if a huge number of people make certain comments and they're particularly detailed, and they either brush those comments off or they just disagree with them summarily and their reasoning is garbage, then you can potentially challenge the final rule in litigation by saying it's so-called arbitrary and capricious. You might have heard those terms before. And a rule is arbitrary and capricious if, number one, among other things, it fails to account for an alternative solution. In this case, I think a lot of the changes that they're proposing now could easily be made with the existing CVIS system. Okay. Another way a rule can be arbitrary and capricious is if they ignore a huge part of the problem. So if you guys point out some major issues with impacting the economy, impacting schools, or if the schools themselves start talking about, this is going to overwhelm our offices because a lot of these schools have one-person offices and they're going to be doubling or even tripling the workload. So if they don't respond to that at all or adapt the rule to accommodate those concerns, then that's another alternative way of potentially getting this rule stopped. So I think even if we do have that 60-day period to adjust, I think during that 60-day period, we're also likely going to see a lot of different lawsuits filed by either schools, companies, or maybe even groups of individual students to try to stop it. And I think at least one of those lawsuits will probably be successful in at least delaying the rule. But ultimately, I'm not too optimistic about whether it can be stopped altogether because if you look at the immigration statute, it does give the Department of Homeland Security a lot of discretion to regulate student admissions and scholar admissions. So ultimately, it's probably there are going to be some changes, but it's going to take a while for the dust to settle, and it might still be a year or more before we know that. Okay, so just make sure that you're paying attention, that you stay plugged in with Go Elite, and make sure that you pay attention to their updates. So, this is the $64,000 question. I'm seeing all this harmful stuff that's going on, and I feel like I'm in a slow motion train wreck. What can I do to stop this? This sucks. And I totally agree. I work with students all the time. This is devastating. I talk to kids on campus, and this is the number one question I'm getting right now. So, what should you do? The first thing is to consider submitting comments. Okay. How do you comment? Well, it's actually pretty easy. This is one of the things that the government's done right in recent years. They have this website called www.regulations.gov. And all you do is you go in there and then you enter the rulemaking number for this particular case. And you can find that on the proposal. It's right at the top. And then there's a couple of boxes. You just enter, your subject line, and then you just enter the text of your comment, and then you submit. And there you go. It's already going to be officially part of the administrative record. And we'll talk about what you should and should not consider commenting about in a couple of minutes. Like I said, you can comment individually, but it might make more of an impact if you did it collectively as part of a group. If you have a campus organization, that is uniquely impacted, then you might want to band together and collectively draft a comment. If your department at your university is going to be affected particularly by this, then you might want to talk to your advisor and get some faculty involved. Make the universities aware because some smaller universities might not necessarily be 100% on their radar, but they have to understand that this is going to be really devastating in terms of international student enrollment if they don't do anything about it. So the universities have a lot more resources than individual students. They have their own attorneys. They're called general counsel. So they will want to loop that in with the International Students Office to potentially work with them to submit a comment. And comments from universities are going to be very impactful. I mean, individual comments certainly worthwhile, but a comment from a university is probably going to be viewed more seriously than from an individual student. Comments can be made anonymously. So some students are like, oh gosh, in this environment, I'm really worried about sticking my neck out. If I say, John Smith submits a comment and he doesn't like this proposal, is Donald Trump going to go out and find me and put me in removal proceedings? And the answer is no. That's not something they can do. But if you really are concerned about it, you can submit a comment anonymously and it will still be considered. And it's very easy to do through regulations.gov. And then, and this is what I'm going to get to in a second, is you got to unfortunately know the audience. And I know this is painful to put on your Donald Trump cap, okay? But this is who's going to be reading the comments. It's not going to be other people at your university. It's not going to be other sympathetic people. It's going to be people from the Trump administration, okay? So when you are crafting your comments, you've got to craft them to be persuasive to the Trump administration. So things that are, heartfelt things about, how long you've been here and how this is devastating to your career plans. Unfortunately, they don't care about that stuff. I know it's really hard to believe, but they don't. It's hard to believe, but they actually want this rule to go through. And even if you tell them it's going to reduce the number of international students, they like that. This is what they like. Okay. So you've got to really couch it in things that they actually care about. They care about America first and about stealing jobs from Americans and all this stuff. So you've got to understand that when you make a comment, that's who's going to be reading them. So when you're drafting something, keep that in mind, and we'll talk about that in a second. So here are some examples, and this is the last slide before I'll open it up to questions, but sort of just examples of what would be maybe a good comment or what would be considered a bad comment. Okay, and we'll play a little game here. So the first one, if I put a comment in there, say, this would be devastating to my ability to do day one CPT. I really like to work for this for my employer. While at the same going to school, and if I'm not able to stay or do a second master's, then I'm not going to be able to do this anymore, and it would be devastating to my employer. Do you think that's a good comment or a bad comment for the Trump administration? Probably a bad comment because unfortunately, you can read the preamble, you read everything that comes out of their mouths. They seem to think that all these international students are just stealing jobs away from those hardworking American citizens. And they're going to think, oh, well, then this makes me think that I'm doing the right thing because we're going to get rid of day one CPT. We're going to get rid of these second masters, and that's going to open up all these magical jobs for American workers. So remember, I don't agree with this at all, but you've got to understand who's going to be reading these comments. Okay. Second comment, here's another example. So I say, well, eliminating second master's degrees is unfair because it's so hard to get H-1B and there are no other good work visa options. Do you think that's going to be something that the Trump administration is going to be receptive to? Probably not, for the exact same reasons as above. They don't want international students sticking around and taking American jobs in their view, and then this is just reinforcing to them that they're doing the right thing. Okay, so these are the types of things that I absolutely agree with these comments. I think they're totally right on point, but I'm not the one reading the comments. I'm not the one with the power to make changes to the rule. The people with the power to make the change to the rule have a different set of priorities than you and I do. Okay, so what's another comment here? So eliminating second masters makes no sense because getting an MBA after a specialty degree contributes to economic competitiveness. Now I think we're getting warmer. I think that's going to be a good comment because I don't think that just reading this rule, they foresaw this as a potential impact because this is a very common career path. It's like I get a degree in a hard science, but then let's say I want to go understand how to market some technologies or research that I've done in Silicon Valley or somewhere else. I then think it's useful to go back to get a second master's, which would be an MBA. This is a career path that lots of people blaze, and it would now be foreclosed under this rule, and it would probably hurt the American economy. So that would be the opposite of America first by depriving them of skills that they need to do to remain innovators on the world stage. Because remember, America first. We want to make America number one. We're contributing to America being the leader in Silicon Valley, leader in technology. And if you don't allow us to have this particular career path, then that's no longer good. Then that's going to possibly be in jeopardy. That's going to be more of a comment that I think they would be receptive to. Okay. Next one. These restrictions make me want to study somewhere else and compete with Americans from abroad. Is that a good comment or a bad comment? I think that's a good comment because it hits them right at America first. I mean, we are, deserve it or not, seen around the world as at the foreground and the touchstone of higher education. We're the leaders here, okay? And if all of a sudden there's a brain drain, and people start to decide, you know what, maybe I'll go to the UK, maybe I'll go to Canada, maybe I'll go to Australia, and then I'm going to compete with Americans from over there, then they might start to feel that brunt, feel that economic impact, and be more receptive to making changes to the rule to maybe liberalize some of these things. So, what are the changes they could make? They could potentially extend that 4 years to maybe a 5 or 6 year period. Maybe they could keep the grace period. Maybe they could allow certain changes during graduate programs if it meets certain circumstances. Maybe they could allow for people to do a second master's degree as long as they can justify it in an application. So this is definitely not set in stone, but it's really incumbent upon you and your allies to get the comments in to make the administration understand the full gamut of what they're about to do so they can make changes before it's too late, before they face expensive and extensive litigation. So my contact information is up here. If anyone has questions about the comments or if they have any suggestions, if they want me to take a look at comments that they've drafted, I might be able to do that for a nominal fee. But other than that, I mean, I really encourage people to participate in this process, and hopefully we can get the administration to walk back from what seems to be a pretty devastating proposal. So, with that being said, I'll open it up to any questions that you all might have.
Thank you so much, David. This is a very, very comprehensive presentations, everybody. I think all of us have learned a lot. And then I see lots of comments, repetitive comments or Q&As asking for more instructions on comments and templates on how do we actually writing those good comments. I just wanted to have my own personal opinion, just that this is some type of a situation where it's tricky that you don't have a copy and paste situations. Like everybody's scenario should be a little bit different. I see people mentioning about AI. Sure, everybody use AI to kind of makes what you write even better, even more appealing. But at the same time, understanding that the government has technologies to detect AIs or to detect duplication. So that's why we don't. This session only serve as a general guide to kind of opens up everybody's vision to kind of see that how comments can work and what kind of angles that you can aim for. But never, I will advise never believe something online that says that, hey, use this comment and this will work. If everybody say the same thing, that probably they will just lower it down to a duplication and then they don't really care about that. So that's being truthful to the specific situations and from what David has said is very, very important. And without further ado, I will open up the Q&A sheets. Our moderator, Shama, in the background have collected lots of questions, and I kindly ask everybody to upvote the questions that you think is relevant. But I'm going to go ahead and share it. So these are the questions that most of the people are agreeing to. We're going to go by one.
Okay.
And if in any reason we skip your questions, we have no intention to do that. Please scan the QR code so we can connect you with David or our consultants to provide more resources to help you with these commenting situations. So number one questions. How does this affect Day 1 CPT? Does the students have to leave the country even if they, for example, they already enrolled in Day 1 CPT? If this rule have passed, no more second masters, how would they affect them?
Yeah, I mean, it just depends on whether you're already enrolled in one right now or whether you want to do one after the rule takes effect. If the rule takes effect and you already have one master's degree, then they're not going to allow you to enroll in a second master's program. Okay, that's just a categorical no. If you are already enrolled in a or third master's and you're on day one CPT, then you are going to be allowed to continue on with this program. It's just that once the rule takes effect, you're not going to be allowed to continue it for any more than 4 years from the day that that rule takes effect, plus that 60-day period. Okay. So you can continue on in the same program, but it's also, if you travel and you re-enter, well, guess what? Then you don't get to, then you're subject to the new rule. So it's really something that you're going to need to keep an eye on. And to the extent that you can enroll in and start a day one CPT program before the effective date of the rule, I would certainly encourage doing that.
Mhm. And I think this is the similar answer to the next questions. People are asking about how this rule will be applicable to students in the US with the F1 visa. I think you just mentioned that kind of the similar scenarios. If they wanted to exit the country, then come back, it might be acceptable to them.
Yeah, exactly. So yeah, if you're here on duration of status and the rule takes effect, then that duration of status, while it says DS on your I-94, you really are only allowed to remain in the US through the end date of the program that you're currently in. So let's say that the rule takes effect on September 1st of 2026, and you're here on a program that ends on May 20th, 2027. Well, that's really what your end date is. You're only allowed to be through May 2027. And then if you wanted to extend beyond that or apply for OPT after that program, then you would need to file both an extension application and an application for the work card. So it really is going to be a lot more cumbersome unless they make changes to that rule.
Absolutely. And next question is not directly related to the proposal itself, but a lot of people are interested. So, for those who wanted to start day one CPT, is it true that it's not convenient to do day one CPT because potential impact on immigration future changes?
Well, I think actually the opposite. I mean, I think now it's still an option. I would recommend doing it. And I've done lots of presentations on this, and there's absolutely nothing wrong with day one CPT and participating. And a lot of rumors are out there about, oh my gosh, I'm not going to be able to get a green card. I'm not going to be able to get H-1B. And that's just never been my experience. If you're in a reputable day one CPT program and you're able to make that connection between what you're doing in the classroom, what you're doing in the workplace, which almost any reputable CPT, day one CPT program is going to do, then I've never had any problems with anybody getting H-1B or a green card. Sure, have there been RFEs? Absolutely. Have I ever had a denial? No, I don't think I ever have. And I've been doing this for a very long time. So there's nothing wrong with doing it, especially if you think that the days are numbered in terms of being able to enroll in a second or third master's. I would certainly do it now, before it's categorically off the table as an option if this rule comes into effect.
Mhm. Next question is a very important question to us, and then is an interesting question as well. So, what would be, as we talked about this, we would not offer any specific templates to anybody trying to comment, but overall, I think David has given us some kind of examples. And this question is about what would you suggest we write in public comments, and some of the points that could be like a good point, a pro point to second master or the DHS rules. And then also, uh, how if anybody have the capability, how do we encourage Americans around us to be participating in this? What are their angles if they wanted to comment?
Well, yeah, that's an excellent question. Well, first, I'm going to talk about an anecdotal example of myself. Okay. When they were making some proposed changes to the H-1B program back in 2016, they put out a proposal. And I identified an issue with the proposal where it was under-inclusive of what the current policy was. And what they were proposing, they said, oh, we want everything to be the same as it was before. And I identified a place where it wouldn't be the same. So on my lunch break, I just typed out a very quick two-paragraph entry into regulations.gov and I sent it in. And lo and behold, when that final rulemaking came out, they identified me as the only person who identified this issue, and they changed the law in response to my specific comment. So the moral of that story is number one, don't obsess over, making it so wonderfully written, florid prose, all that stuff. It doesn't matter what the format is. It really just matters what the substance is. Here I was on my lunch break. I just typed in a couple paragraphs and I ended up changing the law. So if I can do it, so can you. Okay, as long as it's the substance of it is actually really compelling. In terms of getting Americans involved, I mean, I think that's really important to sort of first explain to people why this is a big deal, because it's not an easy rule for you to sink your teeth into if you're not in this world. Like, you all understand what duration of status is. You all understand how important that is, and how all these changes are going to really wreak havoc in your lives. But a lot of people don't understand that. So maybe just explaining to them about how this would really overly burden you, and to the extent that you guys might be planning on something after graduation, if say a startup or something like that, and now you're not going to be able to stay because getting OPT is going to be such a pain in the butt now. That might get them interested. But the Americans you want to focus on are really the people at your universities, right? Getting these university administrators involved and getting these comments submitted. I mean, they have resources beyond which any of us can even dream. I mean, they've got lawyers on staff, millions of dollars. And, I don't want to be crass here, but if they lose a lot of their international enrollment, that is a huge, huge sucker punch to their finances because you guys provide a huge economic impact. And if they understand that, then they're going to be more likely to rally behind you guys and submit a really comprehensive comment. So that's how to get Americans involved, and those specific Americans. But generally, in terms of what would be a good comment, would be a bad comment, just the stuff that I talked about. You know, remember your audience. Don't obsess over the content. It doesn't matter if it's perfect grammar. You could just do something during your lunch break like I did, but if it's sufficiently persuasive, then you could potentially result in a change to the final rule.
Absolutely. All right, moving on to the next question. So, if I apply for a master program that has a 2 year length, and then my new I-20 will reflect that, would it be very, very difficult to stay even 1 year after the master's for an OPT, let alone 2 years of OPT extension? I'm assuming this case is
Yeah.
assuming that the new
The new
rule is not
rule. Yeah.
effective.
Yeah, I mean, well, let's just walk through how it work if under the new rule. All right, so I get my visa. I come to the United States to start my master's program. It's going to be a 2 year period. Okay, so I'm going to be admitted through the end date. So no longer duration of status. I'm going to have an end date on my I-94 that coincides with the end date on my I-20, where they said I'm going to be completing my master's program. Okay, and then if I want to get OPT after that, then like I mentioned. You'll have to file not only the I-765, which is what you get for the work card, but you also have to file an I-539 to request an extension of up to 14 months to co-extend to be coextensive with your EAD application. Okay. Now the question is, well, is there a chance of denial? What are the standards? And it's really nothing I can predict right now. I mean, I don't imagine that it would be denied, except if you messed up the application or if you file late or something like that. But substantively, when they make CPT or when they make OPT available, then they also need to make a mechanism available to you for you to extend your time to access this available benefit. So I would think that in almost every case that they should approve it for that additional year plus period to do OPT. But we're dealing with the Trump administration, and your guess is as good as mine. But my anticipation would be is if they make this benefit available, then they should also allow you to extend your status so that you can access that available benefit.
Mhm. And then one thing I would add from an international student's perspective, David, please correct me if I'm wrong. It's just
Yeah,
that a lot of us have gone through this route of applying for the OPT,
yeah,
getting OPT, getting EAD card, started working, and now you have this new rule implemented if it getting passed that people have to apply for separate things to be able
yeah,
to start. So this could be a challenge if you are interviewing with an employer that you have to explain more things to them. Back then, it was like I need to get my EAD card, so I can get started with working to you. If I don't have the proper work
yeah,
authorization, I cannot work for you. And right now, you have to worry about one more layer of things, which is extending your status. So that might also create barriers for the employee side to hunt down for a job. And it also creates barriers for employers, which are trying to hire international talents, and then they have to wait. And then maybe some of the positions they're hiring more urgently. So definitely right now, if you are those type of people commenting what you feel about the situation could definitely be pretty important for that. So let's move on to the next one. How does it affect students who are currently doing day one CPT with an expired visa? Would it ends existing students day one CPT? So visa status is two things. I think right now is a pretty good time for David to briefly introduce to us what would be the differences comparing to students' visa and then their statuses.
Yeah, the visa, I mean, think about it as just an entry document, right? That's the document you need to present at the border or at the airport to enter the US. Once you're inside the US, the visa doesn't matter anymore. What matters is your I-94 record. And right now, your I-94, if you're an F1 student, is going to say duration of status. If this rule takes effect as it's currently written, then instead of duration of status, you'll have a fixed end date. But and no circumstance, either DS or with a fixed end date, is the expiration date of the visa ever going to be important. Meaning you could have your visa that's issued for 3 months. Some countries actually do have visas that are issued for that short length of time, but you're still allowed to remain here for years as long as you have that I-94 card the I-94 record that says DS and you have an active CVIS record, or if you have an I-94 that admits you through several years, okay? But if you do leave the country and your visa's expired, then you will need to apply for a new visa at a consular post. And because you have to re-enter, then that entry document becomes valid again. But then when you re-enter on that new visa, then that visa expiration date doesn't become important anymore. Then again, you have to worry about the I-94. So it's just a sort of cycle like that.
Yeah, absolutely. All right, next question. I really hate to do this, but we wanted to focus this one specifically on F1. So we don't really have enough time to talk about the other visa type that are definitely being heavily impacted. Maybe if we host another session, we can talk more about JNG visas. But let's just focus on the next questions, which is a more realistic question. So my stand OPT expiring next year, January. Should I try to enroll in CPT or into a second master program this year in October? As the rule might change, might kick in, later this year or next year.
Yeah, I mean, unfortunately, well, it depends on how much time you have left on your STEM OPT. I mean, if you still, I think if you said it was expiring next year, then yeah, I
Mhm.
think I probably would recommend exploring enrolling in a day one CPT program before this rule takes effect. But if you still have like a year and a half or maybe a full 2 years left of STEM OPT, then I mean, I think that you probably can just stay with what you have. But again, remember back to my original presentation. I think there's a chance that litigation is going to slow this down. So even if it does get proposed as a final rule, I think at least there's going to be some delay of many months before it actually takes effect. So that might give you some more wiggle room to try to find a day one CPT program if you're interested in a second or a third master's degree. But if you have the opportunity and you have it lined up and you've identified it, then it's probably better to just have the certainty of enrolling, even if there might be a possibility of getting this rule delayed further. That's just my
And
perspective.
I think your comment kind of addresses the next question is these people wanted to know, what if I enroll before the rule take effect? And then we have discussed this in the previous comment. So we're not gonna answer this once again. We're gonna hopefully have more time to answer more questions. So next one, what if your F1 visa has expired, but you currently have an active I-20? Um, until very later in this in the F1 status stage. How does this inspire visa impact your status as an F1 student? And what we have discussed about, if you don't leave the country, the visa does not really impact their status. Is that right, David?
Correct. Yeah.
No. All
It's
right.
only
So.
it's only relevant as an entry document. Once you enter, you don't need to worry about the visa expiration date.
Okay, so next question, which is also a great question, is the extension of stay a new process, or did it existed already on other visa types? I think it does. So I'm in the
Yeah.
PhD program, and most of the students need extra years other than these 4 years to be able to complete those programs. So how could they go about with those process?
Yeah, I mean, look, the form that they're going to be using for the F1 extensions is the same form that they use for every other non-immigrant category, pretty much. So, like people who have H4s, L2s, B2s. So that's a very common thing is I come in as a visitor and all of a sudden, my 6 months is coming up and I need more time, then I file an extension on that form. So it's all going to be on Form I-539, which has been in existence since pretty much time immemorial. So yeah, I would imagine that it's going to be no different for filing that. It's just that what you need to show is going to be different. So unlike some of these other statuses, for this one, you'll need to have an I-20 that's been issued by the school that's signed. You'll need to show that you have sufficient resources to pay for the tuition for the extended period, and you're going to actually have to explain why you need this additional time. And there is an element of discretion there. And we're just going to have to see how that plays out because this is a completely new thing. And the best thing we can do is just to prepare these applications as well as possible, follow the instructions. And, you might want to use an attorney to prepare these things to make sure that they're done correctly. I mean, I certainly would be available to do that. But, if you don't use me, make sure that you use somebody else who knows what they're doing.
Yeah, absolutely. So next questions, I hate to do this, but in terms of when the new rules will kick in and how it will kick in right now stage, I don't think I am capable to answer this question. I don't know if David are capable to answer this question. So there is so much things that are unpredictable, so I don't really have a timeline for you guys. But this is also a sign of reminding people that comments does matter. and how you comment, how many people comments can actually eventually change the timeline and also change the result, the end result of how this
Yeah.
goes. What's your
Well, I
opinion?
will I will say something here that the Trump administration tried to do something very similar to this when they
Right.
were in this before. And you can maybe take some you can read something into the timeline there. I think they proposed it in September of 2020, right? That's when they proposed the rule. So the comment period closed in October of 2020, but they were not able to get it finalized before they left office in January. So from that, it shows that it took at least 3 months for them to go through the comments, and they were not able to do that in time before they left office. So, again, we're not talking about where they're going to go through these comments and be able to make a final rule in 2 months, maybe not even 3 months. It might be 6 months or more before they do it. So, I mean, to the extent we can guess, we can just look at what happened under the prior administration and try to extrapolate a timeline for this one as well.
Mhm.
But like
And
Ryan
and
said, we can only guess.
definitely, David. And then due to the timing, I think we are running out of time. But if we have so much questions and students concerning, do you mind maybe we stay a little longer so that we can answer a couple more questions?
Yeah, sure. We can
Sure.
do a few more.
Okay, thank you so much. And then one question I don't see it in here, but I think is a lot of people's concern. A lot of people talk to me about this. I think I will ask on behalf of them. Some people are hesitant about commenting because they fear right now with social media vetting going on,
Yeah.
with international student background check going on, they feel in some ways if I'm gonna say something and then submit it to this government website, it's gonna be on my record and then it's gonna do negatively on my record, like it's gonna impact me in any way. So what's your opinion on this and what would be the truth if people does submit comments?
Well, yeah, I think I might have addressed this briefly in my presentation, but um, I don't think there's any basis or really any reason to be fearful that they're going to try to retaliate against individual commenters just because, it's part of American life is being able to participate in the civics process, right? So, much like writing to your congressman or writing to your senator should not impact anything. Submitting a comment shouldn't either. I mean, that's part of our our democratic process. But like I said, if you're really concerned about it, and I certainly understand it, given anecdotal accounts of what's happening, all the social media vetting and all that. If you're really that concerned about it, then like I mentioned, you can submit a comment anonymously, or you submit a comment as part of an overall group. A group might be putting together a comment, and you can sign on to that. And generally, your name won't be appearing in the administrative record. But I understand it's a dangerous and dicey time. But if you got something really important to say, then don't let the fear of potential retaliation keep you from doing it. You can always submit it anonymously, and they will still have to consider it.
Mhm. Okay. All right. Next questions. We're trying to do two more, maybe two, three more. Just skimming through these questions. Next one would be more about the PhD side of the thing. So if somebody who currently have already completed a master program,
Mhm.
uh, um, and then they have a rightful status to stay in the US. But if the rule kicks in and they wanted to start a PhD, would
Yeah.
that immediately apply to them as the extension of stay? And then also their new I-94 will change or something like that
Yeah.
if
Well,
they're in
if
the
you
US.
are, yeah, if you're still doing your master's program at the time the rule takes effect, then you can do a PhD program. It's just that you would need to file an application with immigration to get an extension of stay to approve both the extension for you to continue on as a student to start that PhD program, and also to actually approve the elevation of the degree level from master's to PhD. Now, you're only going to get 4 years. Well, that's not long enough for most people to complete their PhD, which is a huge problem, which I think a lot of people are going to be pointing out in the comments, and which I would encourage you to do as well. But if they don't change that 4 year maximum, then in the middle of your PhD program, you're going to need to file another extension that's going to be supported by an I-20 issued by your school through the anticipated end date of when you think you're going to get your PhD. So if you're going from master's to PhD, you might have to file as many as two different I-539s, one to change from master's to PhD and get that initial extension of stay, and then the second to get that extension beyond 4 years so that you can complete your PhD program. So that's what I envision as being the pathway unless they change this rule and hopefully extend that 4 years out to a more reasonable period.
Mhm. All right, next question. I think we kind of addressed it in our previous questions. Is if the rule takes into effect, we don't know when, but if you already had a U.S. master, then you won't be able to do a second master. So if you wanted to do day one CPT, you were gonna have to go another way up, which is the doctoral program.
Right.
But since now the rule has not finalized yet, so if you're looking to enroll this September, maybe October, it's not finalized yet. But after that, I'm not sure what the timeline would be. So we wouldn't offer you any specific time. But understanding this process is unpredictable and it might take longer, it might take shorter, we don't know. But if everybody send in the comments and then lots of comments are about the second master, maybe they will revise some of the policies about second master and maybe doing a second master in a different field would be possible. So these are all the
Right.
possibilities.
Exactly.
Okay. All right. I'm just skimming through this. Let's just answer maybe one more question. And then extension work, I think we talked about this. New process, yes. And then day one CPT, we have talked a lot about this as well. Selected H. Oh, let's talk about this H1B, right? So I was
Yeah.
selected for H1B this year. Submitting
Hmm.
this, so already submitted the petition, but haven't received approval yet.
Hmm.
So my day one CPT, I'm also under a day one CPT, so my CPT will end soon. Should I apply for a OPT at the moment, or should I wait to see if I can get the H1B approved? I know this might not be 100% related to the F1 proposal, but judging from the climate that is going on at the moment, should the person wait for the H1B or should the person apply for OPT?
Well, I mean, I really can't opine on that other than because I don't know what the H-1B petition is. I mean, most of the H-1B petitions I file get approved. So I don't know if there is any particular reason why you're concerned about whether this is going to get approved, if you don't think it's a specialty occupation, et cetera. So, and the H-1B is going to take effect on October 1st. So that's like less than a month from now. So, I would probably, if they don't have an answer yet, I probably would recommend upgrading it to premium processing instead of having to go through the stress of maybe having to go through a completely different process. And by the way, even if you file an application, there's no guarantee you're going to get a receipt notice even before October 1st, unless you file online, of course. But that's just I would just say if unless you have any specific concerns with the H-1B, uh, or if you think you're going to be losing your job before October 1st, then I would just let it ride with the H-1B and not deal with
Yeah.
the other stress.
Yeah, absolutely. I think we're gonna end with this one last questions, which I think is a good question a lot of people wanted to ask. So I have travel plans, right? I
Mhm.
wanted to travel outside of the country. I want to visit my home country. But realistically, if was considering this proposal going on and right now the political climates, if you ask me, I wouldn't advise you to travel if you wanted to get a new F1 visa. But what's your opinion, David?
Well, as many lawyers will say, it depends. It depends on your personal circumstances, Again, I think I've talked about this in some of my prior presentations on day one CPT, which is not all F1s are alike. So if I've just gotten here and I'm in the middle of my first bachelor's program, I have relatively strong ties to my home country because I just came from there, then I don't think there's going to be that much of a problem with traveling, assuming that you don't have any problems with your social media or anything like that. But if I'm here, I'm on my second master's, I'm getting day one CPT. I haven't been back to my home country in 8, 9 years. Then it's going to be a lot more dicey in terms of either getting that visa or maybe even getting readmitted to the country if you do have a valid visa. So it really depends. Definitely something that you will want to discuss with your international student advisor. But to the extent that you are deciding to travel and all other things are equal, I would recommend traveling now before the new rule takes effect rather than later, so that you can at least have duration of status instead of a fixed end date.
All right, this is it. Thank you so much, David. I know we ran over time for this time, but we have gathered lots and lots of questions from the students, and I really think your presentation and addressing those questions are really, really helpful when it comes to circumstances like this, where as international students, sometimes we cannot predict what's going to come. We only know, what's before us, what we can do at the moment. So for those of you in the audiences, we're going to keep hosting sessions like this in Chinese and also in English in the upcoming weeks. We're going to talk more about the F1 proposal and then commenting and then until the final expiration date, which is September 29th. So if you have additional question, if we didn't answer your question this time, make sure you tune in. You go to our website, sign up for other webinars as well. But I wanted to give a special thank you to David. I know you have been very busy lately. And then thank you for joining us, offering lots of your insight. And hopefully we'll see you soon again.
Thank you. Don't lose hope. Keep up the faith, everyone.
All
Take
right.
care
Thank
now.
you, everyone. Take care.
All
Thank
right.
you, David. Have a good
Bye-bye.
night. Bye bye.
Sure.